In this video, we will answer a recent question from one of our viewers. How do you go about withdrawing a guilty plea in a criminal case? The answer to that question is coming right up. Welcome to Gustitislaw. If this is your first visit here, I'm Steve Gustitis, and this is my channel. If you're interested in learning how to navigate the criminal justice system, or how to manage encounters that you may have with the police, or how to defend criminal charges, then consider becoming a part of the Gustitislaw community. You can do that by simply clicking on that capital black and white G down in the lower right-hand corner of the video screen. As part of the Gustitislaw community, you'll receive weekly videos about these important and interesting topics. If you like today's video, consider giving it a thumbs up, and don't forget to watch the video until the end, where I will provide you some critical legal information and counsel about withdrawing a guilty plea in a criminal case. The main attack upon a guilty plea, or no contest plea for that matter, is to allege and to prove that the plea was not knowingly and voluntarily made. Now, for the purpose of today's video, we will assume that a defendant has pleaded guilty and has already been sentenced, as withdrawing a guilty plea prior to sentencing is a different process and often much easier to achieve. The document through which a person would raise an involuntary plea allegation would either be through 1, a motion for new trial, or number 2, a writ of habeas corpus. Motions for new trial are generally governed by state law and by strict time limitations. For instance, here in Texas, a person only has 30 days following the date of sentencing to file a written motion for new trial. Writs of habeas corpus, on the other hand, generally are not governed by time limitations and can be filed anytime after sentencing, provided that the motion for new trial is not available to the defendant. Both methods allow a person to make allegations and to develop evidence to prove that their plea of guilty or no contest was not voluntarily made. Both methods also can result in a hearing where witnesses can testify and other evidence can be admitted to help prove the claim. Reasons for an involuntary plea can take many forms. For example, one reason for an involuntary plea could be that the court that accepted the guilty or no contest plea had made mistakes, and those mistakes affected the voluntariness of the person's plea. Another reason for an involuntary plea could be that the prosecutor has failed to comply with terms of a plea bargain agreement. A third reason for an involuntary plea could be that a person was denied legal counsel at some critical stage of the criminal proceedings. A fourth reason could be what we call ineffective assistance of counsel. That means if a person's lawyer, either through their action or their inaction, caused a person's plea to be involuntary, that can be alleged and proved in court. Some of these reasons for an involuntary plea require not only that the defendant allege and prove that a mistake was made, but also prove that they were harmed as a result. For example, if a person wanted to allege and to prove that their lawyer provided ineffective assistance of counsel by failing to investigate the case prior to the guilty plea, not only would they have to have shown what the proper investigation would have turned up in the way of evidence, They would also have to prove that in light of this new evidence, they would have decided to plead not guilty and have requested a jury trial rather than pleading guilty. An example of a reason that does not require proof of harm is where the person has been denied legal counsel at some critical stage of the criminal proceedings. In that type of a case, harm is presumed. Making and proving a claim of an involuntary plea is both legally and factually complex. As a result, please consult with a criminal defense lawyer in the state where you entered the guilty or no contest plea that you want to withdraw. That lawyer would be in the best position to help understand the legal principles at work in that state and to help you be able to prove that your plea was involuntary. Now for that critical piece of advice that I promised you at the beginning of today's video. If you win your claim, if the court allows you to withdraw your guilty or no contest plea, your case will revert back to the beginning, and you will be compelled to defend your case all over again. And taking your case back to the beginning may place you at greater risk than simply accepting the consequences of the guilty plea that you believed was involuntarily made. It's the perfect example of be careful what you ask for, because you just might get it. If you like today's video, give it a thumbs up and consider sharing it on your other social media platforms. Thanks again for watching, and I'll see you next time here at Gustitislaw.